PREA policies. It's not the DOC's PREA policy, but we have the.
That's the distinction between the DOC responsibility, which is the enforcement and inspection. It's the licensing side versus who oversees the juvenile facilities, which is not DOC. It is whatever the county board is, whatever the, right? So I agree, it needs to be clear, but that is a distinction.
I think we're required to have a PREA, like, even though, like, we're required, like, when I have licensing next month, like, they're going to want to see my PREA policy. So, but like, obviously the DOC doesn't create my PREA policy. They don't create any of my policies, but all of my policies are like based on the requirements of the DOC.
So I think we do need to table the juvenile thing, but I still will say there isn't PREA in juvenile facilities. Maya does it in hers. Some of the other facilities might do it, but it's not in licensing, so it's not a focus.
Right. I think that's what we talked about
Yeah.
last month,
Yeah.
that would be the next step, is to ask DOC to include some sort of PREA requirements for licensing in juvenile facilities.
And then hold people accountable.
And then, so I feel like we should look at this now and then put on the agenda for next month. Now, how do we have a conversation about DOC licensing, applying it to juvenile facilities?
Don, can you scroll down a little?
Yep. It is good that some of them are doing it on their own well, but it would be.
And I can say I've seen there be a response to a PREA violation through investigation by DHS, but I think that also lends itself to the confusion we've had of, is this a DOC issue? Is DHS overseeing it? And we just need to have clarity for the safety of our kids that are in custody to know who is in charge of licensing the facility, who's enforcing it.
The thread from last time that I know that goes along with you is we need the woman from DHS to come and talk about PREA. She wasn't able to come when Liz and Gina were here, and that was the missing information. So whenever we put that on the agenda, somebody's got to invite her to another meeting. She wasn't able to make it, but that would fill in the gap on the juvenile side.
Don and I will work on that.
Did we decide we are going to read through the document? So is everybody through the sexual abuse? That all looks accurate to me. Okay, we'll go down to B, please. Yeah, that looks, because that is consent. Only if they don't consent. The first one says either way. That's because it's so that sounds right. Great. I think, can we go down? I know some people are just reading out.
I guess I have a question about a sexual abuse advocate, an individual who has completed 40 hours of sexual violence advocacy training, is employed by community-based program. Is that an and or an or? Because I would imagine there are some therapists who could be sexual abuse advocates who are not working with a community-based program, but are working on their own.
I can answer that.
Yeah.
So that is about, that's required by statute for sexual assault advocates working in community-based agencies to have confidentiality, to have protected confidentiality. So I'm assuming that a therapist already has that and wouldn't need it.
So would we add though, just so that they don't, I feel like this could be used then to say that if they're not working for a community-based program, then they can't be a sexual abuse advocate. So maybe we would add language that says, or a, licensed social worker or therapist, so that they don't get blocked from.
I think that's really, that 40-hour is very specific to the, so I think it should be like, if I'm a therapist in a group home, I should have to go through that training, or even if I'm in a residential. Nikki wasn't, because we went through this with Safe Harbor. We had everybody go
Yeah,
through
I
that
mean,
40-hour training.
I
that you
don't think
guys do, and
therapists, I mean, advocate in this sense means something very specific. It's someone who knows how to do safety planning. It's someone who can help do court advocacy. Like it's a very specific kind of thing that I don't think therapists are trained. I don't think therapists and advocates are the same,
No.
So
but I
Cory,
see
is
there's-
your issue then the 40-hour training, or is it the community-based?
Community-based is my
Okay,
issue. If
okay.
you have
So I-
somebody that's has their own, is a therapist, perhaps has gone through this, but isn't working for a community-based program, has their own program, is that still considered a community-based program?
Add
Nikki's
context.
knocking.
That context,
saying no.
the statute, the
Uh-huh.
PREA statute actually delineates that there is community-based advocacy. And so
Uh-huh.
that's probably where that comes from. So you're adding a level of distinction I don't thought of, so.
Yeah.
So
the
that's just-
community-based program is in here too because there are also advocates who work in prosecutors' offices. They do not have statutorily protected confidentiality. So this is about this, as defined by statute, is about confidential, like statutorily protected confidentiality.
So should there be an and instead of a comma?
Yeah, that would be my thought.
Oh, Angela.
Yeah, by statute, yes.
Yeah.
You have to have both of those pieces.
Yeah, okay. Angela, did you have a comment?
Oh, yeah, thanks. On the document that was sent, there is an and there. It says and has been accepted into the DOC's Victim Services PREA advocacy program. Is that been struck from
See that
this
that was-
document?
Yeah, I don't know whose edits those are. Yeah, it's crossed out of this one as well, and I'm not sure why they did it, but I mean, in a way, it just I guess it. Is this not talking about those specific programs that are contracted, like that's how I'm reading that.
Yeah, the statute
the-
says we have to have a formal relationship with community-based organizations.
Right. So
And this
this,
is what that.
somebody struck it out. I'm assuming maybe they struck. Well, this is the one that was circulated. So I'm assuming that it was struck maybe by the PREA folks who are working on this for some reason.
I believe that what we have is the current version of the policy revisions that they are working on. So yes, it
So
would be
I'm
from the
not- this
policy
one you
chairs.
Okay.
I think that's a clean version of what we're, of the.
Yeah.
This one.
So I'm curious as to why maybe they wanted to strike that.
Yeah, it seems like that would be appropriate in my opinion, but I don't.
Isn't it kind of, without it, then it is broadening it to other people. It's broadening
Yeah.
it, which I don't have a problem with because there may be providers that haven't been, accepted into a PREA advocacy program and maybe they're not screening programs anymore or don't want to. So I don't.
Can't someone from Shakopee, can't a woman in Shakopee call any DVSA hotline they want to call?
If they have the number, they can call anybody they want to.
Right.
If it'll accept their corrections, so.
Yeah.
Right, so it might be struck out. I'm just thinking, I don't know, we can ask for clarification, but because, I mean, theoretically, the confidentiality of sexual abuse advocates is broad. It's not limited to who DOC contracts with, right? Like
I
a woman in
tend to agree.
Shakopee could call any hotline, right? And have that protection.
But Nikki, if they call anybody on any hotline, those calls can be enough and are recorded, so
Oh,
they're
sure.
not necessarily confidential in that respect.
Crystal?
My logistical question is whether it would be beneficial to have the tracked changes version up on the screen.
Probably so. Yeah.
Great, thanks, Jen.
Here we
There we
go.
go.
It does say that it was changed by Gino.
Yeah,
Well, I'll-
thank you.
Yes.
I mean, I tend to agree with the change because it would allow more programs without the bureaucratic red tape of being pre-screened by PREA. And that gives more access to legitimate programs or people by women. So I would,
But I think that this is what PREA says you have to have. That's
then
the
you
issue.
can't strike it, you think?
Do you think
Maya?
that's true?
Yes.
It is.
I'm pretty sure that is what it says, like that we have to have, like, I think this is almost word for word out of like the PREA standard. So I don't think we can change it too much based on what we think would be better. because we have to do what Priya says they
I'm
are expecting.
And I'm only guessing here, but we wouldn't restrict somebody calling an advocate of their choice. But if the confidentiality is the thing that is important to them, we have to be involved with that because we have to be able to get them on a special, we have to facilitate.
So I guess the question, maybe, is anyone writing down some feedback and questions that we will be sending back? Somebody be in charge of that? Okay, Vicky said that she, because my question would be twofold. One, and maybe we can track our own changes in here too. One would be, all right, what is the DOC's process for screening victim service advocacy programs? And two, what made them decide that they want it? Why are they thinking that they should strike this?
So we determined this was done by Gino.
Well, and
Right.
yeah, Liz. So I think we just put a comment in there,
Yeah.
Liz and Gino, what's the
Like, comment.
reason of
I can
that?
Who is Sophie Polinsky? That's the actual, okay,
What?
that's the actual DOC person that
The
was.
current.
It's gonna be the people who are working on the
Sure,
policy,
yeah.
so just
Services.
all the questions, comments will go to
Why
the right
are
people.
you considering? Okay. Striking this. I'm just hitting send on this. I don't know if it's gonna go anywhere, but I'm doing my own tracks with these comments along this document and then I'll send it along. That works. And then you're also. So between the two of us, hopefully we'll get it going.
I think our ask will just to get a combined copy.
Okay, yeah, okay.
All right. So anything about SART? Issues with the SART section? Okay. Oh, go ahead, Angela.
Thanks. I just see this in red. It said the exam needs to be done within 10 days of the assault. Is that stating in red that means they're going to strike it, or is that just emphasized as highly important?
I think that's an addition.
Okay.
Yeah, it looks like an addition to me.
Angela, given your expertise in this area, do you think that's a reasonable addition, or do you think it should be even shorter?
I mean, ideally it's shorter. Ideally it's like 72 hours, but I don't know how. Yeah. I mean, ideally it's much shorter, but I also know that, victims may not report it within that period of time. So maybe their rationale was that they could buy more time. I'm not sure. Because it says 240 hours of the assault. But if victims don't report it until after that time, then are they just going to be given an exam whenever? I mean, I guess it seems like it's trying to be helpful in theory. But how I read this is that if they don't disclose it, if victims don't disclose it within that period of time, they may not get the exam.
So what if we put this will occur within 72 hours, because that's to preserve evidence, I'm guessing, right?
Yeah.
Of the assault, if reported, within 72 hours of its occurrence. 2 hours of the incident, and then otherwise incident, if it is reported longer, outside of 72 hours, then what do you think would be reasonable?
Then I think that, I think that language about 10 days is fine. If they wanted to keep that in there, but I just don't want it to be this, long drawn out.
Yeah.
The victim reported it. They were waiting for an exam or an assessment because it's not specifically in there.
In either case, this should be done as soon as possible.
Correct. Yes.
Madeline Adams has her hand up.
Go ahead, Madeline.
I agree. Everyone, I had my video off because I am just having some bandwidth issues, so I'm sorry. I'm like the speaking head in the room. I when I'm looking at how this is framed is that the policy is to bind the actions of the DOC or whatever the agency is. So it's not reflective of when a woman reports this sexual assault, it's what her people that are, or the who is caring for her, how they have to respond. And so I agree with the amendments that we're going to be proposing in order to ensure that whoever is in charge of her care is getting her that exam within 72 hours. So I don't know if it can we streamline the language for it to be that this happens within 72 hours of the offense and not put any language in there that places onus on the victim for when they're reporting it, but be really clear that it has to happen within 72 hours of the offense. If more than 72 hours have elapsed, then as soon as possible and no more than 10 days.
Yeah. You're right, because they could, yeah, because they might know about an assault that she hasn't reported.
Right. I just don't want to, I want this to be clear that we're binding DOC and whoever holds those licenses and not putting anything on the victim.
Yep. So this will occur within 72 hours of the assault. And then how would,
If reported within that time.
well, that's what we don't want it to be with that language. This will occur within 72 hours of the assault.
And maybe just something like with the victim's consent. So then
Yeah,
it's
assault if known and the victim consents. If it is reported, would we say if it is known or if it is discovered outside of 70, maybe we just take. I like the idea of them having like a end cap, but I hear your concern about giving that and putting it on woman. So right now I have, this will occur within 72 hours of the assault if known and the victim consents. Should I put if known by the DOC or reported and the victim consents?
What does that mean? Like
So-
if they find out about it and the person has not reported it?
Right.
Okay.
How do we cover that? Because I mean, if
Okay.
they find out about, because if we just say if it's reported by the victim, then they don't have to do anything unless it's reported.
Mhm.
If we put something down like if it is known by the DOC, so like if somebody else knows about it but she hasn't reported it, they still have to go and offer her the exam within 72 hours.
exactly like how do we force them to offer her that exam?
So I would say if known by the DOC or any staff members.
It's odd to me because known is like, how would you know? You
Okay.
can say that it's been reported, that doesn't mean you know.
What about if suspected? If,
I see both.
I feel like on the outside, I don't want someone telling me, come in and offer me an exam when I haven't said anything or asked for it. So I don't know why they would, a person inside would.
So this is making me, does anyone have the copy of what the PRIA literature they give the women there? Because I'm thinking as a side note, I can be starring, like, is that outlined in there of like, when they're given all this information about their rights and this and that? I'm wondering if that is a way, no, this isn't this, but you know what I'm saying?
To make sure that it's consistent.
Well, to make sure that it's known, yeah, that the 72-hour window is.
Well, we don't even know that they're gonna change it to that. These
Right.
are just suggestions.
but does the consent language take care of your concern? Like they can, if they think that something happened, they can approach and say, hey, we think that something might have happened. I want you to know that you have the right to get this exam, but if you want. I mean, I feel like information is power and they should at least know that they have the right to do that. And they should at least know that they, you know, and given like any evidentiary concerns and the best medical practices, they should be given the option to choose within 72 hours.
Can I ask some clarifying questions? Because I feel a little bit confused right now. So in this scenario, if the DOC, Jeff, let's say like you saw on body cam footage, one of your correctional officers engaging in sexual activity with an IP. First of all, that would be like there is no consent, right? So
Correct.
Jeff, you would be moving up your own hierarchical ladder, right? To address the correctional officer because that is a crime, right? Like
Yeah, I'd be reporting a crime, removing the
Right.
person from the facility and reporting a crime, yes.
right.
If we saw it,
So
yes.
so in that case, then like the victim would be taught, there's things that are going to kick into place for the victim as someone who is the victim of a crime, right? Which this would be a part of. I'm just, but if I guess I'm struggling with if it is known. I don't know what that means. Are we talking about something was seen on a body cam? In which case, if it's an officer, it's a crime. A whole bunch of things are going to happen. Did they see? It is known. They know two folks are engaging in sexual activity together, and they don't know if that's consent. Like, because that is also like not allowed. I just don't. I don't know how this known would happen and what it looks like. I'm struggling to wrap my head around that because that would then determine how I think the victim would be approached.
I think that's.
I'm sorry, struggling.
Yeah. Well, in my mind, I was thinking, Nikki, along the lines of your hypo. Like they see it on body cam footage, they go through their process and get police involved. That may take longer than 72 hours. In which case, nobody's offered the victim any sort of medical services. Right?
I would like to add, I think there's a lot of reasons why we would know without the victim reporting it. Like, I think victim reports are the least common for me. It's usually reports from the other residents, so, and on all those kids, there's immediate offer of like care. And I don't think, I mean, I think the concern, it seems like in this conversation is that we don't want them to feel like we're forcing them to have a sane exam. And that's not, I think, the purpose here. It's if we know about it, we should be offering it to the victim is what I think what the conversation is having here. And I think you're bringing up a particular situation where like we know about it, the victim didn't report it, we're doing an investigation. Like I think it could easily come up in that conversation, right? Like if you have the right staff involved. I think that we're kind of making this conversation a little complicated. I think I agree that if we know about it, regardless of whether or not they reported it, we should be offering the same exam. I think that there could be some sort of distinction in terms of we're not forcing a sane exam, like, but yeah, if we know about it, there needs to be an offer for a sane exam as soon as possible.
The problem with as soon as possible is that that's wishy-washy, which is why I would like to put the 72 hours in and then,
I agree that it's wishy-washy, but I also agree that like what if we didn't know in the 72 hours? Like if it's if it's 78 hours, like we don't want people going, well, now we can't do it. So
Yeah.
But we have a medical professional, and we also know from practice that 72 hours is really important. And so I do think it is an evidence-based suggestion that would stand up to any scrutiny of why this is being asked for at this point. We have a really firm explanation to that. And then we can add that additional language that Corey had thrown out there about, well, what if it doesn't happen in the 72 hours? We can go with what's already been proposed, that it happen as soon as possible, but no later than 10 days from date of known report.
So I guess is the hang up in a way like the known factor, and do we need to flush that out more? So would we put something like this will occur within 72 hours of the assault if it is what do you say, known? If the DOC or staff have reason to
Known or
believe it an
suspected.
assault, if the DOC, has reason to believe that an assault has occurred or if it's reported.
Say if they have reason, because report would be
An
contained within if
assault
they have reason.
has occurred. Well, I don't want them to have any way to say they don't believe her, so that the assault has occurred or it is reported by the victim.
That just seems
By the
redundant.
victim. I know, but I'm imagining situations where they are like, yeah, she reported it, but I don't find her credible, and so I'm not gonna do it. So I'm trying to remove that discretion. So reason to believe that an assault has occurred or it is reported by the victim. And then we could start another one, the victim must give their consent. The victim must consent. And in cases of delayed, or in cases of delayed.
One thing that might help, this is still just the definition section.
Yeah,
The rest of the policy talks about the steps and the things that are supposed to happen.
okay,
Yeah.
well,
And Savannah's
I'll just put it here.
recommending something as well. Same offer, but accepted. Yeah, and it does have that way elsewhere. It was so big. They're on my desk at home. I know. I'm gonna.
Are you good?
Yep.
Okay, yeah, and just, we should keep in mind, this is just the definition section, that there are more, there's more about the process later in the document, so.
And we can refine this, but what I have now is this will occur within 72 hours of the assault. If the DOC has reason to believe that an assault has occurred or is reported by the victim must consent. And in cases of delayed reports, then no later than 10 days of the report or reason to believe that an assault has.
Sounds reasonable. All right, we good with the sexual harassment definitions? They look appropriately expansive to me.
A lot of language.
Yeah.
Yeah, I'm good on that.
Okay.
I'm good
All
with
right, can we
that.
go to staff sexual misconduct, please? It's comprehensive to me. Are we good?
Mhm.
All right, can we go, so we can see the allegation definitions, those unsubstantiated, okay. All right, so there must be language later in the document about unsubstantiated, substantiated, and what was the one before?
Unfounded.
Unfounded.
Unfounded,
Okay.
yeah.
Yeah.
Okay. So those.
I wonder if we just cross out for the purpose of gratifying the sexual desires of any person, because we have a lot of inappropriate behavior that we do not want to occur. And I think just adding that additional layer of proof that we also have to prove that this staff, contractor, intern, or volunteer did any one of these things in order to gratify sexual desires, like, is that necessary? Is that true with the purposes of PREA, that it be for their sexual desires, or we just don't want this sexualized behavior, period?
I think it's in the definitions of PREA. I can check.
Would we be allowed to be more protective than PREA if we want to? I mean, I would think as long as we're not being less protective, we would be okay, but if we're being more protective, Because I tend to agree with Madeline. That's definitely something that people would try to use as a defense, like, oh, it was a mistake, or, oh, you
Well,
know,
and
I
I
had
guess
no,
that's-
you
I
know.
was doing it because it was a joke,
Yep,
you know, like it wasn't sexual. I was just joking around.
yep.
In the
But
pre-
isn't the DOC trying to put language in there to protect themselves from strip searches? From unclothed body searches? Because otherwise then like an unclothed body search would fall into some of these, wouldn't it? Like that's why I think that language is there. But I
There's a
could be
separate
wrong.
Policy about that.
There's a separate policy about body searches, so, I mean.
So it is in the language. The gratify sexual desire is in here several times. Intend to abuse, arouse, or gratify sexual desire. So I'm not disagreeing that we could be more protective, but just knowing, just so you guys know, that's where this language comes from.
Don, could you roll it back so we could all see the sexual misconduct section again?
Yeah, sexual.
Yeah, that's, yeah, you're right. It's right. Yeah. I mean, I think probably the voyeurism thing too, like just because prisons don't have a lot of private spaces, just people getting dressed and things like that. Maybe that's to cover them from, you know, those kinds of situations. I'm like Maya is saying. Where they weren't really trying to see someone getting dressed, but happened upon it somehow. I don't know. I mean, I'm guessing that's why that's in there, and I don't know if I worked there, if I would want that taken out, you know.
So it's in there to protect against like accidental or strip searches.
Well, and it's about
Yeah.
intentionality too. Like staff have to be in supervising when people are changing or in the showers or something like that, but
But voyeurism, like by definition, voyeurism is not just incidentally
no, right.
encountering some. Sorry, Cookie, please don't. It's not just incidentally encountering someone. Voyeurism has part of its definition a sexual intent behind it, that you are viewing someone's unclothed body for the for that sexual gratification.
And it goes into a lot of detail in the parentheses there, I think, so I don't know that they even need the gratifying sexual desires above, because the only one that would pertain to is voyeurism. The only one that,
I
yeah.
think we need to ask them. I
Yeah.
bet they have a good clarifying reason. So before we say get rid of it, I'd say, what's the purpose of this? I'd want to hear that.
Because what Maya's saying, it's the language that.
Yeah,
Yeah.
that's in Priya
That
too.
simple.
Yeah, absolutely.
So here's what
I
I'm,
was around when they did the first go around of the policy a long time ago. And I remember that discussion about the satisfying of sexual thing. And I don't remember the exact thing, but it did fall onto this comes right out of the statutory language or the law.
so I'm just adding a note in here on the document that I'm working from, and I put in, consider that this adds an additional element of proof to the state and allows for people to say it was just a joke. We understand that this is there to protect against accidental behavior or strip searching. This is also the exact language of pre-up. So we
I
flagged it
don't
as
think
an
that does
issue.
what Paula was just recommending though, which is like, ask the question.
Ask Gino and Liz and it could be very well what Jeff just
Ask
said.
them what.
Yeah, the gratifying of sexual desires, though, is about sexual misconduct and it's not part of sexual harassment. I'm not seeing
think-
that in there anyway. So
so
the just a joke wouldn't necessarily apply to that.
The question came up about including the purpose of gratifying the sexual desires. I would ask them, this Please
Just why is it
clarify
in there?
why that's in there. It came
Especially
up
when
in our
they already-
discussion.
They already include it in voyeurism.
Yeah.
They already specifically say that.
So
address
please
it.
clarify why the sexual gratification portion is in
Yeah.
there.
Okay, so we can roll down below allegations now?
So hold on, do we want, have we, Maya, yes, confirmed this is the exact language of Priya, and you think that may be why it's included?
Yes.
Yeah, okay.
It is, the language is abuse, arouse, or gratify sexual desire. So it's actually slightly less specific.
But I think that abuse or like that gives us more information, different ways in which someone could be in violation of Priya that the way that it is stated doesn't. Because I think that if we wanted to, you could be for, their entertainment or for gratifying the sexual desires of any person to kind of incorporate people that may find this to be amusing but not rise to the level of Priya because it's not for their sexual desires. But that language, it sounds like there are two additional ways that it could be in violation of Priya. And we could just add those two different words into here.
So if we add the word for purposes of gratifying the sexual desires of any person or abuse, or how
For
would
the purposes for the purposes of, or it says here, intent to abuse, arouse, or gratify sexual desire.
Oh, yeah. So abuse does add a different
Mhm.
hook. So that
Right,
is
so for
the
the
actual
purpose
Priya
of
language?
abuse. Yeah.
Okay, I'm gonna put, there's more. Okay, so I will tell them, please look at the actual Priya language. Because it states, do you want to read that little thing again so I can get it down appropriately?
Intent to abuse, arouse, or gratify sexual desire.
Use, arouse, or gratify sexual desire. Yes, because I mean, we could make an argument that like inappropriate joking is abusive, so yeah, I would agree. Okay, posted.
I think we gotta go back to Savannah's comment too.
I'm still concerned about the victim must
It's a good
consent,
point.
which sounds like they have to do the same exam or could be interpreted to some mean that.
You were saying.
Would, if I add consent to the same exam, would that fix it, Savannah, for you?
Where's she looking at?
Do you still have the must in there?
What I wrote in my proposed edit is that the DOC within 72 hours of the assault, or this should occur within 72 hours of the assault, if the DOC has reason to believe that an assault has occurred or it's reported by the victim must consent. In cases of delayed reports, then no later than 10 days. So like we're giving.
Yeah, I think that instead you could say like with the victim's consent.
Okay.
It's the must that is sounding like that someone must do this.
The sane exam should be done with the victim's consent.
Yes.
Yeah.
All right, so are we good to move past allegations now?
Yeah.
Everybody?
Yeah.
Okay.
Welcome to being a transactional attorney.
All right, zero tolerance.
I just noticed in number 2, any trained security staff, that kind of limits it to the officer field. So what about other non-security staff? So maybe take out,
Just correctional
Security.
staff.
or you just take out the word security,
Other trained staff.
Correctional staff.
Correctional
and we're all
staff.
trained.
Yeah.
Take up.
I'm putting remove trained security. This should apply to all staff.
No, just the security. It should be other trained staff, right?
Other correctional staff is what I would say.
Okay, right
You
now
know,
it says
they're all
regardless of
trained.
tenure or rank, a correctional
Yeah.
officer, other trained seniors or security staff, just take out security, because then that's other staff beyond correctional.
Yeah, we trained because we have to
Trained
train
staff.
tons of people who aren't security staff.
Yeah.
Yeah.
And why, I mean, even. the
We apply that
trained
trained or
part-
untrained staff. If it's a newly untrained employee, it should apply. So I just think
So,
all staff.
Or
Yeah.
other
I mean, I
staff.
think the deal is right is when we say trained, we're like, because this is about who's reporting, right? So I don't like, and we wouldn't, all the staff should be trained. So I think the issue really would be like if for some reason we had, like if you guys got to tour the DOC, you're not trained staff, you would all probably report something, but you're not expected to. But all this, like we have to train all the staff. And like if they have somebody who comes in and serves meals or you have volunteers, like they all have to get trained.
Can we just say other staff?
I put other staff.
Okay. All right. Other than that, are we good? Okay. All right, can we move down to the next ones, 3, 4, 5?
And it's for number 3, it's outlined in the training or and maybe elsewhere here. People know what the immediate action is. The staff person learns about a substantial risk, which I think is important to differentiate, but then that immediate action is outlined for them. They know.
Well, in the
It is-
trainings, yeah,
Okay.
I know even in the education, people
And
training.
later in this
Tell you
document
what to
too.
do.
It
Is in the
has,
document.
yeah,
Okay.
later.
That's
We could refer, yeah. Okay. I mean, if we wanted to, we could put, you know, in accordance with, and then refer to that section to be specific, or we just leave. I think we just leave it, because
Yeah.
provide.
I think some of this is in the later, more spelled out, so I don't know, maybe if we can do it almost
Sure.
backwards or something, but
Well,
we're getting,
like a
it's where we
policy and
should really,
procedure.
yeah.
Okay. CSCs. You know what would have been done?
Can you roll it up, Don, to number 6, please?
Right, exactly.
I have a weird spelling thing. Is the sexual abuse incident management database, is that the proper name for the whole database, or is it just incident management? Because otherwise it would be. 6. It's a capitalization issue that just sprang out. It's not a substantive.
There's a copy editing team
Okay,
that
perfect.
takes care of those things.
Great. Maybe I can apply for.
Are you on it, Cory?
Maybe if I want to have a second career, it would be. Okay.
Is everybody down through B?
Yeah, I'm on
Can we roll it? I think you can roll it up further now. Be awful to be a youthful IP. Yeah, just because you'd never get to talk to anybody. Yeah, it would be horrible.
I agree. And this is, I know that we're only focusing on adults right now, but when we were talking about the language about, reporting within 72 hours and whether to put that on the victims, I just think about kids and their willingness to come forward and all the vulnerable people that we have as adults that have mental health, that maybe have lower functioning and maybe aren't as prone to come forward as others. And how do we protect them and make sure that they're informed? But I also agree with the language of making sure that it's clear with the DOC, you can't force them to participate in this exam.
So here's a question. I don't know where everybody else is. I'm looking at IP education. Are we all there?
Mhm.
Okay. I'm looking at the IPs must receive written and verbal information regarding what defines a false accusation and the consequences for making a false accusation. So I'm curious as to what that information is and whether it could potentially dissuade people from it.
Yes, it's further in.
It's very victim blaming.
Where is that? Where false allegations?
It's E, 2E.
No, but elsewhere in the document.
So, Corey, what was your question?
Well, I guess my question is, they have to provide them with information about what a false allegation is and the consequences for making it. My question is like, what is this information and will it dissuade people from making legitimate?
Yeah, because they're
complaint.
afraid that someone's say that it's false.
So
Right.
I don't know what page I'm on here, but 4 of 9.
It's
So it was last month or the month before I provided a bunch of information on PREA, on trauma stuff that PREA was part of that. One of the things that we give them is a primer on PREA. It's just called Sexual Abuse Prevention Intervention, PREA Elimination Act. Federal laws, PREA, this is for knowing your rights and responsibilities. So this is given to all of our IPs and that issue. Yeah.
Stuff.
Nope. It's it's more of a Word document. So that is addressed in the, now I can't find it. Okay. So that's addressed in some of the stuff that we give out. There's a heading of a section that says, what'll happen if I'm making allegations knowing they are false. So we have a policy, I don't know the name of the policy, but it's cited here, the number is cited here, defines false allegation, and differentiates between all of those two. So
What's the policy number?
103223.
So in this document, false reporting under C2, if an investigation reveals that an IP has made a false accusation of sexual abuse, harassment, staff sexual misconduct, they will be held accountable through the disciplinary process and or referred for criminal charges. So this, from a trauma standpoint, not good at all, because I've worked with victims, young people victims, who couldn't say what was really happening and said this other thing to see first how we would handle it. And if that's true, that's all part of the trauma responsive behavior. And so whether they know that information ahead of time, Jeff, when people are in their trauma reactivity, they don't necessarily think, oh, I remember that time. It doesn't work like that. So it seems like there's nowhere in here that if somebody, for whatever reason, And if it's not to gig a staff they hate,
Right.
you know, there's no room for any of that. They're gonna be punished.
Mhm.
And then that just piles on the additional trauma. So that's re-victimization. So
So-
that language in this policy here, there's no room for anything else.
Can you
So-
tell me what number you're looking at so I can flag it here?
C2, it's right before D.
C2.
It's IP reporting.
False reporting. We'll just put, this is not trauma informed language. And we have concerns.
Or process, yeah.
So,
Jeff, what do you
yeah,
think?
so to, I mean, this is anecdotal, but I've been around in part of the discipline unit stuff for a big chunk of my career and at a number of different facilities. And I get what you're saying about the language and all of that, but this is to more assuage that we don't often go there with regard to saying you lied, we know it and we can prove it. See the pointing finger, the shaming and all that? That's what we do, the corrections. And so I cannot recall in my 30+ years in corrections and my connection with the discipline unit, of which for a time I've overseen, that we've ever in relation to PREA, where we've ever said, we know that we're gonna discipline you for lying because we know that you're making.
The
I'm not
problem is
gonna
they don't
say
know
that,
that.
I'm not gonna say that it doesn't.
And the policy says, yes, it will happen.
Right, because
Well,
the problem is they don't know that, and I'm sure you guys don't tell them that,
They don't
right?
know what.
That you aren't gonna enforce what you're allowed to enforce, right? So
Well,
like,
no, we're-
maybe we take it out.
Yeah, if we know that you are.
I think that-
lying, we should. I mean, it's a discouragement to lie about.
But it's not that clean cut for victims. There's no processing for a victim to say, if this is what's coming up for me right now,
So,
I'm gonna say Vicky put her hands on my breast, when really it was Joe over here who was sexually harassing me. I'm not thinking about, maybe I better check on the written information I was handed. It's not, doesn't work that
no,
way.
I get that, but the challenge then is how in a process, how do you fix that in process? So you're doing the right thing
Well,
for everybody.
I'm just saying, the language doesn't leave room for any kind of, mental health, like the mental health caseworker saying, whoa, hold the horses before we press charges on her. Let me give you some additional information that I've been working on with her, and this is a pattern. This is a trauma response pattern or whatever, but it's not, it comes out of her trauma, not her, I'm just gonna make shit up because things are a little quiet around here.
Are there policies elsewhere outside of here where there are consequences for lying about something?
So 103, let me look at that.
Not in
Yeah.
PREA, I'm saying outside of it.
Mhm.
Because I don't know why it needs to be in PREA when it's probably a rule infraction to
Otherwise.
lie anyway. So
It
why-
has to be in PREA because of the federal law. They require that we put a statement in here, but I do think that the PREA law says that, like, if the report is made in good faith, and they don't have those words in here. So, I mean, I know that's still kind of a, like, I agree with Paula, like, for a lot of people, trauma is still going to tell you that then I'm going to get in trouble for making a report. But I do think adding the words in good faith may help a handful more people understand that, like, if you get some of the details wrong, we're not going to give you a consequence for it. But we do have to inform them by law that they could have a consequence for lying, basically. And I think that's the distinction. Like, this is saying false reporting, and I think that's the terms they use in PREA. But really what it is like intentional lying, which a lot, when we're talking about those people that Paul is talking about, they're not usually like, they're not like intentionally lying. Like they're having like a mental health response, right? Like that's different.
What we know about sexual assault is a lot of details get confusing and blurry. It's
I agree
hard
with you.
for them. for
Yeah,
the
I
person
know.
to know, yeah, so I'm agreeing with you as well. Just
So
Yeah.
the term in good faith is in that document that is given to the people.
Okay,
Okay.
it should be in the policy because
But it's not
policy
there.
is supposed to be followed. And if something's in the policy that isn't, it doesn't have enough information. That's all I'm saying, is that the language needs to change, because that sucks.
Okay,
The
so
way
what
it is right now.
Okay, so I'm still up at the top here on E2E. What if we add in what defines a false accusation, comma, made in bad faith, comma, and the consequences? And then we add that language later as well.
Well, can we add the word intentional or intentionally as intentionally?
Well, the
made a
intent,
false accusation?
no, because intent, in legal land, intent, it can be your intention, like, yes, I intended to say these words because I said them, or it could, bad faith gets to the intentionality in a
Okay.
mens rea
And
sense and
the-
not an actus reus
Okay.
sense. So
Good.
I would say consider adding false allegation made in bad faith.
And then
I'll-
I feel funny
yeah.
about that.
Maya, you said it has to be in there.
This is,
There's
I
no
think
like.
the
taking it
spirit of what we're all
They're saying
talking
that
about is pretty clear. I would worry less about exactly how it's gonna be phrased.
It has to be in there, and I think it kind of makes sense, just from the sense of like we should let them know that we might consequence them if they were intentionally lying. Like, that shouldn't come as a surprise, right? But yes, the language does have to be in there.
So if we add the bad faith language, that kind of adds a layer of protection.
Yeah.
At that top one. Yes, we'll get.
For me, I'm hung up on maybe it's over in the C too. If I don't know anything about sexual assault victims, my God, I'm gonna use this policy, right? So there's no assessment. I guess I like assess whether it was in bad faith. What was it? In good faith, that, there should be some kind of assessment of that, instead of just somebody who, who's really angry. Yeah. Who wouldn't be angry if somebody says something that's scary? Well, I probably wouldn't be, because I'd understand it. But if you don't understand, then
I think, I mean, if they want to, I don't know what we're giving to the inmates, and maybe that information should be in what's given to them, but like the person who's going to decide that this is a false allegation isn't going to be the CO who's walking the floor every day, right? Like the people who have to do the like investigations in the facility are highly like we have to go through all kinds of training,
That's not our discipline staff either, and probably not yours either, Maya. Sorry to interrupt. Yeah, that's our
You're fine.
OSI who does the investigation and sometimes outside law enforcement.
But any facility, if I run a facility, my staff are gonna give the information. If we all decide, this little cookie's lying. So I think the language still needs to be in there somehow. Because otherwise,
You mean about an assessment?
yeah, assess if this was made in good faith or bad, something like that. And if it was made in whatever the word bad faith, I don't.
But it sounds like that's already part of the process
It's-
with if the
oh,
investigative people are doing that. Sounds
I'm
like an
still on
assessment
IP
is
report.
I've worked in
part of the
facilities where
process.
everybody circles the wagon and they say, this is what we're gonna say to the investigators or licensing or whatever. Now, maybe that never happens, although you guys have been through some stuff with, and then people being rehired, had to be hired, that
was
kind
a
of stuff.
Union issue though. That was
Sure,
the
but-
union
but
made that happen.
What I'm saying is the policy, as it's written, seems like the only focus is on getting somebody law. And that is that's my
Yeah,
hang
no,
up
I
on
hear
here.
you.
It's not trauma
I wish we
informed.
could take it out, but it sounds like.
So
we
it sounds,
can't.
well, I
So-
think we can. I think we
Or
can
add to
add
it.
the language of reveals that an IP has made a false accusation of sexual abuse or in bad faith. They will be held accountable. And we could add language too, saying that efforts shall be made to consult with an advocate or a trauma,
Yeah.
whoever is working with this person, to have that conversation before,
Yeah. Put them inside, yeah.
yeah.
Hey, Maya, I'm not trying to throw a wrench in things here, but can you link to what you're looking at? Because the national standards that I'm looking for, I can't find that language. So I'd love to see what you're referring to. Thank you.
So there are technically there's also this is also just something to keep in mind for because I know you guys were talking about, do we want to recommend they adopt this for juvenile? Like, a lot of the language and the standards are the same, but there are two different things, right? One for juvenile and one for adult. So just I'll put the links in a minute here.
So Corey, the term used in the brochure that we give out to them is malicious or manipulative.
Very,
intent.
I don't like that word manipulative.
Sorry, I just saw that.
Yeah, I think,
Well, why does anyone manipulate?
yeah, we all manipulate.
Yeah.
And it's a survival skill, yeah.
Mhm.
And
To get
girls
an
are always
email.
like,
Okay, well, how about something like, here's a suggestion. There should be some language about false accusations, bad faith. This again is in response to Paula's thing. Also, there should be some language requiring consultation with a trauma-informed mental health sexual assault practitioner to determine whether a false accusation
Was malignant?
is due to a trauma response or made in bad faith.
that would be awesome if all that was.
Yeah.
Well, hey, this is our
Just to-
opportunity
yeah,
to give them the
put that
gold
in trauma
standard,
response. I
right?
mean, yeah, that's
Like
great.
this is our opportunity to give you guys give everyone the gold standard. You can do with it what you will, but like there are these people on staff, right? I mean, you have relationships with people in these community organizations. It wouldn't be that if you're seriously considering disciplining somebody, which you say rarely happens anyways, it would make sense that you would consult with somebody like this and just have that conversation as part of your decision.
I'm not sure anybody disagrees.
Did that link work?
Yeah, and I
It looks
agree with
weird.
what
Clear,
you
like I'm
put
not
in there.
Yeah.
like,
I don't know.
we're good.
So,
What, Maya?
sweet.
I said, did that link work? It looks weird.
Oh.
That's the prison one.
That's
I'll
the
give
same
you
one. It's the same one I linked above.
So what was your concern?
I can't find that language that you're sharing about in good faith. When I can cut and paste in Slack here, the inmate education piece in this standards document does not say anything about
Let's see.
talking about false
find it.
accusations with inmates. That's why I'm just struggling right now. I can't find this good faith language, any language about that.
In the
Let me
PRIA stuff,
see
in
where
the
I saw
national
it.
PRIA stuff.
Sorry?
Mhm.
In the national PRIA stuff that you're looking at?
Right.
Okay.
I'm just trying to clarify, because if we're saying something has to be in there because of national standards, I just want to make sure
It's consistent.
we're clear on.
Yeah. Yeah.
I think that is also what the people who oversee this policy can respond to, right?
Absolutely.
Like they can, I don't think this group has to worry about like getting that answer in this moment.
Yeah.
I mean, there's like 40 minutes left. There's still a ton of policy left. So I think like how to get the spirit from this group of like the types of questions that you have, the things you want to know about
On
is
page
I think what's
30.
going to be most useful to our policy team.
I agree.
Okay, so what if anything should I flag related to this conversation? Or are we good? Nikki had a question about the PRIA. Nikki, do you want me to flag something specific, or Maya, do you want me to make a note about your requires or wear handouts anywhere?
Don, can these links go in the notes, please? The links that they're putting in the chat?
Seems to.
Okay, that's helpful. I see the good faith piece there. I'll just say, and this might be getting too in the weeds, but if we look at what the national standards say around inmate education, they don't include anything at that piece of the piece about informing inmates about the consequences of being untruthful.
Okay, so,
Right, like that's not a part that comes up in the disciplinary, like what to do if an inmate
Policy,
report
right.
something in bad faith, but they're not like preempting that on the education side. And I think that's part of our concern is front loading that on someone is doing some unintentional work
Right.
to create fear and shame, right?
Bingo.
That would prevent good faith reporting versus like having disciplinary policies about like addressing dishonesty. But it sounds to me like the conversation we're concerned about front loading that on people, right? Like what does that do to
So, Nikki,
someone?
I'm writing, please look at the national standards. What should I refer them to?
The page number for inmate education in the national standards is 115.33. It starts on page
Is 115.
17. And I will put in the chat here the entirety of what inmate education at the national standards includes. There's the whole text. So there's just not that piece about like getting, you know, front loading the consequences onto someone, which I think is something we really need to consider, especially if in other kinds of ways we're not front loading that on people in response. Like, yeah, of course you're going to have disciplinary policies around dishonesty and all that. I get it, right? But like you have to, like that's important. But when we're talking about something that is so stigmatized and secret and shameful, and especially women are coming in with these experiences already, like what does it potentially, what's the unintended consequences of front loading that onto someone? If you make a false allegation, here's what's going to happen to you.
Yeah, Nikki, can you tell me what document you're referring to so I can put the title in here too?
Yeah, and it's the same one, Maya. It is the Prison Rape Elimination Act, Prison and Jail Standards from the DOJ.
So Nikki, it sounds to me like what you're saying is we could actually take that entire section out because it's not mandated. But I would say
It's not in the it's not in these national standards if that what they're if that's what this document is referring to and based on, it's not there.
But if it has to be in there, then the other wording if they determine that they're going to keep it, we'll ask them to at least add that.
And there's two different
The
things.
good
There's
faith, yeah.
education, and rather than say, if you lie, you're going to be in big trouble, which you don't want to do for victims. But in the policy for DOC, the false reporting, that's a separate issue, and you kind of put some stuff in there already.
All right. What I said is, what we said about the bad faith stuff and consulting with, here's what I wrote. There should be some language about false accusations made in bad faith. Also, language requiring consultation with a trauma-informed mental health sexual assault practitioner to determine whether a false allegation is due to a trauma response or made in bad faith. Please look at the national standards, inmate education and national standard 115.33, page 17, Prison Rape Elimination Act, Prison Standards. We could also potentially pull this language because it's not in line with the above standards. So I think that sufficiently flags it, yeah?
Is it possible, I'm looking at time too, I was just saying to Corey, just down from the false reporting is responding to reports of sexual abuse, D, and I'm looking specifically at DE5. Involuntary segregation should only be assigned when another alternative cannot be found and must not exceed 30 days. This is for a victim. What does that mean? And what are the alternatives? And why would we ever put them in involuntary seg? And especially, even beyond 3 hours, let alone 30 days.
Right. Yeah. When is this used and why is this used?
Well, above it says ensure that separation is not a form of punishment, but involuntary administrative segregation is punishment.
Yes.
That's not.
So I don't understand
It's
that.
not
It
like
looks
a
like that
safety
one
measure.
that they,
There may be times when the victim and perpetrator is confusing and we don't know. There may be situations that arise. We come upon somebody or we come upon people doing prohibited acts and we just don't know what's happening. Now, we could separate them in different areas. We could separate them from everybody. We probably would because we want to isolate so we get the best information. That's the only thing that I can think of where we might do that when we don't know and we can't establish a victim.
So, huh?
I think this is where
We
if you
need to
read the
ask
rest of the list, this is like immediate things that need to happen, and 30 days being here is throwing it off because it feels like, oh, that could last a really long time. So I think there could be a way to better clarify what this is actually intended to.
But I would question the involuntary segregation to put them in seg for that. You put a victim who's just been victimized again, who's already,
This is not necessarily about the victim. This is just saying, how do we separate two people?
but it says involuntary segregation, that's not for staff.
Right. I'm saying if there's multiple people, they're trying to figure out how do we just get people separated from each other?
And there's no other way to do that than seg?
It's saying if there is no other way.
But my concern is, what are the alternatives cannot be
Yeah.
found in your facility? There's no other alternatives and that 30 days, I don't even understand that at all.
Right.
So
because it wouldn't
I
take
have
30 days for
separate
different
issues,
dates.
and so I can address the one for investigative purposes. It may be the most necessary to temporarily isolate people. Just because we need the information, we cannot determine at the time what exactly is going on.
So then maybe
Now,
we
the
just
30
say
days
that,
is another issue.
you know, maybe we just make it clear that if this is being done to determine who is a victim and who is a perpetrator, then this should be reworded to make this explicit. And the time frame should, I can't imagine that it would take 30 days to determine that.
Oh,
Should be reduced to, or as minimal, well, you want to put a cap on
This
it.
doesn't, so that thing really worries me. If that's in there at all without any explanation.
Yeah.
And I find it hard to believe that there's no other alternatives to that in your facility.
And again, I don't have direct experience with this, so I'm guessing based upon my working in a facility for a long time. It's not just necessarily separating the two people. It's also preserving what goes out in the information. There may be witnesses in the elsewhere in the facility. There may be people who know we want to isolate those folks. That may be a reason to do. And that's the only reason that I can think of at the moment.
So what I could recommend then, I think this goes back to like, we don't have the people in this
Yeah,
room who
we
wrote
need to
this
talk
and
about
understand. So I think that's, again, how do you put in there? Like, we have a lot of questions and concerns about this because this is how it reads to us. What is the intention behind it?
What,
Does it need to be?
Right, exactly.
Well, I will just add that I think this is pretty much word for word what's in the standards. So I actually share your concerns, Paul. I've never understood what victims I would ever put in their rooms for 30 days. Like, does it make any sense to me? But I think it seems like they just pulled this directly out of the standards.
Yeah, it's like isolating folks with suicide ideation by themselves in a locked room.
yeah.
It's like,
Okay, here's what I wrote. When or why would we ever segregate a victim? If this is being done to determine who is a victim and who is a perpetrator, then this should be reworded to make that explicit and the time frame should be reduced. What is the intent of this? Does it need to be here and does it need to be 30 days?
yeah, I would make it stronger that this shouldn't even be in there. Like that involuntary segregation of somebody who just experienced potentially, allegedly, whatever the word,
We should never involuntary segregate a victim.
I'm with you, Crystal, that we need to go back to Chino and Liz and say, we have concerns about this. We know it's in the standards, the national standards, but this is not trauma informed.
I've flagged it, so
But
let's.
she said it was.
So the way that I'm kind of interpreting, it is in
Yeah.
here, 30 days, and it's kind of worded like to keep them from a likely abuser alternative means of
I'm the
separation
abuser in seg.
from
Really?
likely abusers. No, yeah, I'm not,
it's
I'm just
crazy.
saying,
No, I know,
It's-
I'm
yeah,
killing the
yeah,
message.
it's, the way it's reading is is problematic, but I think that is, yeah.
So I guess I go back to, we can always be more protective of victims, I would think, and
Then
then like
let's-
make
yes.
clear, add things, one would think, but I think it's been.
What do you do? I'm just curious, Jeff. What do you do with a CO that's been accused of rape? How do you isolate them?
We put them in a separate work setting.
Or they could be locked out and
Or limited.
not allowed to enter the
Yeah,
facility.
yeah.
It says here, sure, the perpetrator, alleged perpetrator does not have access to a phone and is supervised until the arrival of OSI or law enforcement. Does that happen?
To staff.
I guess I. That.
Okay.
Can we restrict them from leaving? Specifically?
Yeah, if there's an alleged crime, you should. Okay.
I guess I have a question too now about B, offer the, and Angela, this goes to you. It says, offer the alleged victim support and explain the options. The alleged victim may choose to undergo a sexual assault forensic examination if it occurred within the previous 240 hours at a designated emergency room or other designated facility to conduct a sane exam. Why would it, that makes it seem like they can't get any sort of exam done if it occurred outside of 240 hours, like,
That's how I read it too.
so
think-
I feel like we want to like get them in quickly, but we also want them to be allowed to get one at any time. Right?
Yes. Yeah.
So, and why 240 hours? Do you have any
10
idea?
days.
That's,
That's
yeah,
what
that's,
they used earlier too.
yeah, so this should be changed to 72 hours, right? And 72 hours. Ooh, 72 hours, and victims should be given this opportunity at any time.
Yeah, and along those lines of 10 days, I'm not sure where they came up with that time frame. I don't even know if we need
It's
to,
not in the national PRIA. I just searched for 240.
I guess we could just ask them why.
And why 10 days? Best evidentiary practices, or best, I'm just gonna put best medical and evidentiary practices.
Are
Would be
really
72
within 72 hours, and if they wanted to extend it, I mean, 5 days is really the max.
72 hours. And 5 days is the max.
It doesn't preclude, doing an exam after, if it's been after that time frame, obviously, because we want people who have been victimized to have that assessment. But if it's this policy, I guess I just don't know why they picked 10 days.
Yeah, I agree. I think it's like, we want to do it within 72 hours, but even if they report a month later, they should still have an opportunity to do that exam and get treatment.
Yeah.
Nikki put something else in here about inmate education.
Oh, the SANE exam stuff? Yeah, in the inmate education.
Well, right there on the.
We do have to offer them medical and or mental health follow-up if they make any allegations. And I think that's later in the policy from the DOC. So like, it's obviously different than a SANE exam. A SANE exam is time sensitive, but we are through the PRIA standards required to like offer medical and mental health follow-up. If so, like if they reported something that happened 30 days ago, then you still have to offer that.
Would you say under C, which is the one below B that we were just talking, if the alleged victim refuses to be examined, document in an incident report and offer what you just said?
I think that's down behavioral health staff.
Oh, it is, okay.
Yeah, it's in D.
Is this that
Yeah.
come down?
Thanks.
We should just be aware that we probably aren't gonna have time to talk about a conference at all. Like, if we're like 10, 20 minutes left, 20 minutes left. A little over halfway.
Okay, Nikki, I added your comment to the IP education section. There are any
Thanks.
other-
I just think that's really inclusive and cool, and I don't know where it shows up in other standards in DOC.
We have.
If there's like a general education standard that includes that, but I think if we can, that's just kind of cool. I like it.
Yeah,
There are.
yeah. If there are other comments, I haven't been paying attention to comments in the chat. So if there are other comments in the chat that you guys want me to flag in this document.
Well, Don, is it okay to include everything in the chat in the notes so that we don't lose any of it?
I can,
Are there any rules against that?
You can download the chat after a meeting.
Well, yeah, that's,
Do
but wouldn't
that.
that make it easier to, so we don't lose some of the good questions and the good comments, and then, of course, anything that's a resource?
Well, I think, is there anything that is in the chat right now, to anyone's knowledge, that I've not audibly told you all that I've put in this so far? Because I think the more, if we have one document,
It's just that they won't,
I've been reading it out loud.
yeah. But it is, I think, not just in this case, but I think there's a lot of good information shared in the chat that unless we write it all down, it's easier if it's in the notes, if that can be downloaded. It's just clip and paste, right?
We're good though. We've called the ones that we've
Yeah.
used.
You got
Okay.
them all.
Sweet. Where are we? Okay, where are we in our document now? Responding to reports of sexual abuse, staff misconduct.
Health services staff, is there anything else?
I have a question about the PREA screening. We may already be past that. I apologize. We discussed this last meeting, but in terms of who is doing the screening and what tools are used, maybe they could clarify in this policy, or is that not?
That's, yeah, I think that's a good idea. So pre-screening, would we put, this screening should be conducted by a trauma-informed trained staff person?
Trained staff, yeah, yeah. And this may be a nursing staff, but I'm just concerned that that is crossed out because we don't know necessarily what training is being provided.
So it was changed to qualified. Are you saying that you're worried that it's not clear what qualified means?
Yes.
Yes, yeah. And just because I don't know what that is it left to each facility's discretion?
Define qualified.
If they could just define it, I think that would help.
That's what I thought you meant. I just wanted to.
Yeah, no.
So what I put in here then is this screening should be conducted by a trauma-informed trained staff person, define qualified.
Yes.
Go back down to.
What is a PCM? PCM,
Where do you see that?
it's under sexual abuse response, we'll start. Each. It's like on the
Yeah, it was
10th
spelled out
page.
above, but I can't.
I don't know.
Following that number.
What is it? Yeah, something.
Is that the start? Search chaired by the AWO.
You might add a note. It is the national PREA standards state, give some good language to it.
Let me see if I, maybe.
Strictly
I'll
limited to
search
medical
for this to help out.
practitioners.
Oh.
Other staff. They could just look at that for.
Okay, what is the, okay, can you give me that?
All of the PCMs are, do not have.
Not ever
spelled
spelled out.
There you go. Okay, what, can you give me that language?
They say. Information that sexual abuse has occurred in the institutional setting strictly limited to medical and mental health practitioners.
So this is in the.
This is the, yeah, the PREA, this standards and rules.
National standards. What is the exact like site for where you're reading?
Like the number or
Yeah.
115,
Mhm.
81.
Okay, that states that this should be done by a,
Medical and mental health practitioners and other staff as necessary.
other staff as necessary.
Not a ton there, but that's helpful. To inform treatment plans, security, management decisions, et cetera. So I think it could be helpful.
Have they, do we know if they have been looking at this side by side with the national standards, or if they're just kind of going off of this document?
No, it's absolutely.
They're
rooted
kind of
in the
like
national
doing a
standard.
side by side.
talked
and-
Yeah, in policy development, we take whatever legal authority is,
Yeah.
to make sure that those.
Yeah, I would imagine a fair amount of responses that we'll likely get back will include, this is the connection to the national standard, this is why it is what it is. And I think that that, you know, is what they should respond with. That's the answer.
It seems like there is some deep. Okay, where are we now?
Did we get the definition? PREA. Should be spelled out
Yeah.
during the first sentence, the fourth.
Okay. So The SART team. Who is on the SART team? Do we have requirements that there's like a therapist or somebody?
Yep, behavioral health is involved. It's in the definition.
At the beginning of the document.
Back up there. Okay. So we're okay with that.
Did you find PCM and pre-op compliant? Policy.
It is, but it's like the fourth usage instead of the first one. It should be spelled out on the first.
That's in the definition.
Oh, is it?
Yeah, pre-op compliance managers.
Oh, yeah, that's where I saw.
But the acronym isn't then put in parentheses, so that's what we can fix to make it easier to.
Question about incident of sexual victimization. This says if through the screening process, staff learn that IP has experienced prior sexual victimization. They must ensure that they're offered follow-up meeting within 14 days of the intake or screening. So that's prior, not. Okay. Do we feel like that 14 days
I think that's the national thing again.
is reasonable? Okay.
I mean, we can still talk about it, but yeah, that's what I was just. Yeah, that's what they, it's like almost word for word.
Okay.
It does feel a little long, but depending on what they find in the screening, it would could impact a lot.
And I'm not as worried about it if it's an older.
Yeah. Oh, so Corey, I'm sorry, they actually have the language I was referring to in B. They've
I
added.
had a question in the chat about someone following it on a separate document. Where exactly are we page-wise right now?
We don't have page numbers on ours.
Well, according to,
Or I
there's
don't have
a,
my printout.
it's not on there, but on my computer, it says we're like on page 5 of 17.
Page 5?
So maybe we want to do we want to keep working through this document? How urgent is our feedback? I mean, when do they need it? It looks like they're still working through it too.
So when I mentioned that I heard that earlier, I think it was, we are going to be moving into the final copy editing phase at the end of this month. So ideally, we would get feedback by the 20th.
Of this month.
Yes.
So it seems like we need to provide what we have right now and then have a subcommittee continue to review it and provide the rest of the feedback. Who wants to be on the subcommittee?
A subcommittee or what we were talking about before. I don't know if that's possible. We were adding.
Whoever had additional feedback and could send it in.
It feels like we will actually accomplish this better if we do it in a subcommittee. Well, I mean,
Yeah, like today, like
yeah,
getting it and
like who wants to be on the subcommittee and pick a date to meet today? And then, because it feels like from past experiences, when we throw something out for feedback, nobody responds. So I think if we were serious about this, we should convene a subcommittee. Just make some suggestions and go from there.
Nikki's raising her hand.
Nikki,
Maya.
Maya, who else?
I will.
Anna? And Angela. All right, sweet. You guys are the subcommittee. Who wants to be in charge of organizing a meeting and sort of like take the lead on communication? out of the four of you.
Does a smile count for a hand raise, Maya?
I think so.
Yeah.
I actually have time next Wednesday at 10.
Next Wednesday at 10, potentially.
I
Throw it
cannot
out
do
there.
it Wednesday at 10. Wednesday at 10, we're meeting our new licenser.
Oh, yeah, that would be
There's
a
a
bad
new one?
day.
I gotta run and get set up for another meeting. Everybody
Okay,
have a
Jeff.
nice month. Nice to see y'all.
Thanks, Jeff.
Hi, Jeff.
Can somebody organize an email to get that squared away?
Yes, who all again? I'm sorry. Wait, let me pull up my email.
Nikki, Maya, Angela, and you.
Wait, Angela, what's the right email for you? Is that,
Uh,
or maybe it's on the new ones? Nikki.
Yeah,
Can you
it's,
send
I
it
can
to
try to,
Tana?
Nikki, Maya.
let's see if I can type it in here.
All right, I'm going to send this with our current changes to Donald? One or Crystal? Who should I get this to?
I was gonna say you should just share it with the members of the subcommittee who are taking it
Yeah,
next.
if you just want to send it to
I
me.
think it needs to come to us first. I will be the point person for the subcommittee when the work
Done.
is at a point that you want to share it back.
So I'm sending this document to
Maya. You're so correct. Well, they doing that? Can I just do a quick update? Okay, so I talked to retired judge, Karen Radius, who started the first girls' court in Hawaii. And she's, even though she's retired, she's very much involved in the current. And so she was about doing a presentation. It would have to be a video presentation because they're 5 hour, let's see, they wouldn't be able to get up at 5 o'clock in the morning. I don't know why. It's 6:54 a.m. right now. So they were gonna, judge was gonna start getting that coordinated with the person who has the people who are doing the girls' community-based continuum of care, and then they'll talk about how they got to the point where they don't have girls in their juvenile facilities. And then Ramsey County, this report, I keep saying it, it's a game changer. It will be a game changer. They haven't published it yet, but Christy Cobb said she could come in December to present, and I think we need at least an hour. The data on this is so incredible. It's like 4,000 girls in Ramsey County over a period of time. These are social service girls that the national folks did research, and it's extraordinary, and their recommendations, a lot of what we've been saying for about 50 years, but a lot of it's just so, it's going to be so helpful to our state. I think it's going to be helpful nationally because we haven't had a good report like this for a long time, and certainly none within this state on data on real Minnesota girls. So that would be December. I will check back with Judge to see if when they might be ready, if November is better or December. I'm wondering if, when you check with Precious, if she could come in November since we're hot on the Priya stuff. November 12th.
So one of the things that I was going to share is I will not be here next month. I can still try to coordinate and see who might attend in my absence, because I would agree, I wouldn't want to disrupt momentum if we don't have to.
Yeah.
So Don and I will work on that. So it might be another member of the executive team or somebody else who will just be here in my place for that one.
Thanks for coming to all the meetings.
Yeah.
It's been great to
Yes.
have you.
It
Really.
has, really helpful. Okay, I'm sending an email right now to Tana, Angela, Nikki, Maya, with the attached changes that I've been making. They're in little comment form, and then it says, you know, attaching it, I'm copying Crystal on it. When the subcommittee is finished, please email the document to Crystal by 10:20. That'd be great.
Yeah, thank you.
Thank you guys for doing that.
Yes.
Yeah.
Appreciate it.
I also just sent an email, included you too, Corey, but we'll go off the one that you just sent as far as scheduling a time and stuff. I was just trying to get
Perfect,
everyone
yeah.
in a chat, so.
If we're going to ever do a conference again. No, seriously,
Yes.
we really need to prioritize.
What date did we talk about? October 2026?
But still, I mean, we need to get a team together. Remember
We
how
didn't say
long-
October.
We said
We're
April, like
talking
spring.
spring.
27.
Yeah, that's right.
Because we were
Thank
saying
you.
October, there were too many things.
That changes it, yeah. Not that we want to put it off. I'm not saying that, but yeah, we just
2027?
didn't think we
Yeah.
could do it this
Yeah.
2026.
That's what I recall from the
Yeah.
conversation.
Yeah,
thank
was
you.
Because that would,
27.
oh, yeah, because that would be really
April
soon.
2027.
Well, then we do that sometime. We should.
But you can't keep kicking it down.
Yeah,
I
because that'll just keep
Well,
happening.
ask Don to put that for a January agenda for sure.
It's been on the agenda every time.
What? What is it? Word?
Conference.
Oh, yeah,
Conference discussion.
there. It's a placeholder. Yeah.
So what do we have on the agenda next month? Isn't somebody coming?
Maybe we are going to try to get a more specific conversation about PREA requirements in juvenile facilities with Precious from DHS and potentially somebody from enforcement, inspection and enforcement as well.
Is it possible to have Jean and or Liz as well?
I can talk to them.
That'd be great, because then it's the, partnership.
great.
And I mean, that was the intention.
I
was
know.
to actually
She
do
just
all of
couldn't
them
make it.
together
Yeah.
because
Sure.
I think we ended up in this cycle where we're still having like half the
Yeah.
conversation
Yeah,
and lots of unknowns and questions and it's not helpful.
I hope Precious can,
We'll prioritize her availability.
yeah.
Anything else? Are we all good?
So good to see you all.
Can adjourn.
And those we can't see, thanks for
Yes.
coming.
Thank you, you guys.